The Premack Virtual Online Law Office presents attorney Paul Premack with this week's legal column, published in the San Antonio Express News on mysa.com and on our website at www.premack.com. This week's topic: if sold, does the value of an inherited life estate stay with the surviving spouse? Question: Dear Mr. Premack, I have a question about the actual meaning of the law dealing with separate property of a deceased person and the surviving children. It says that the spouse inherits one-third life estate in the real property and that the children inherit the remainder of the real property subject to the life estate. What exactly does life estate mean if all the parties agree to sell the property? Where does the money go when it's sold? Can the spouse spend one-third of the proceeds, or is it held in some type of account? From TJS. Under Texas law, when a person dies without a will or without other legally binding plans which distribute assets, then the statutes on intestacy determine how the assets are distributed. Those laws differentiate between community property and separate property, and can get very complex, and are in fact quite difficult to interpret because of how the statutes are worded. For instance, community property will pass to the surviving spouse, but if there are children from a prior marriage, then the decedent's half of the community property passes in equal portions to all the children. This is one reason that it's so important for people in a second marriage to discuss their goals and to make wills or other legally binding plans about the distribution of their assets. Relying on the laws of intestacy can create a muddied, uncertain result. When it comes to separate property, the statute differentiates between the personal estate and real estate. The personal estate, which is the decedent's separate property, cash, stocks, CDs, furniture, etc., does pass one-third to the surviving spouse and two-thirds to the children. The real estate is different. The law says that the surviving husband or wife shall also be entitled to an estate for life in one-third of the land of the intestate, with remainder to the child or children of the intestate. That's the part about which you're asking. An estate for life generally means that the surviving spouse has the right to use and to enjoy that portion of the property until that surviving spouse eventually dies. At the moment of that death, the life estate terminates, and the children from the prior marriage own the entire property. The fact that the spouse gets a life estate in one-third of the land makes a difference if the land also happens to be the marital homestead. In that case, the children cannot interfere with the spouse's occupancy of the house, even though she just has a life estate in one-third of the house. This is because she also has homestead occupancy rights. On the other hand, if the land is not homestead but is productive, say it's a ranch or it has a producing oil well, then the surviving spouse gets one-third of the net cash flow under her life estate. She gets that benefit for her entire life, but upon her death the benefit ceases and vests in the decedent's children. You ask, what would happen if the land is to be sold by agreement of all the parties? How does the one-third life estate work? Does the surviving spouse get to keep the one-third of the sale proceeds, or are the proceeds held for her benefit while she's alive, passing on to the decedent's children upon her demise? The answer grows from the fact that her life estate has an actual dollar value which can be calculated using a table provided by the Internal Revenue Service. During any calendar year, the life estate will have a set, specified value to her. As she gets older, according to the IRS tables, the value of her part decreases since she has fewer years left to enjoy the life estate. If it's sold by agreement of all the parties, then the value of her one-third is cashed out, and the cash stays with her. She can use it in any way she desires. She can spend it or she can give it away, and if she still has it on the date of her death, then it passes to her heirs. It is not held in an account that's reserved for the decedent's surviving children.